The speeches held in the middle of the 1990s. P1321, P1170, P1169, P150, P1171, P1172, P1173, and P39. It's important to note that these speeches call for the unification of all Serbian territories into a single Serb state. Then we have the speeches held at the end of 1990, which became more extremist. P1174, P1175, and P37. Please note that here there is a claim for Serbian territories and Serbian people not to be separated from their homeland. And similarly, and I believe it's very important, it is also said that within this Serbian state, Orthodox, Muslim, Catholic, and Protestant Serbs would all live united. Obviously, there is no trace of any ethnical considerations. The alleged extremist nature does not seem sufficient to have any direct or indirect consequences on the crimes committed, as far as I'm concerned. During the time period relevant to the indictment, the accused took advantage of the situation and heightened it in order to achieve the creation of a Serbian state through force. P1264, P1338, P56, P255, P256, P644, P179, P34, P62, and P56. The very concept of a joint criminal enterprise with its different members was, I believe, challenged by the decision issued on November 10, 2005 by Chamber 3 after the prosecution motion for joinder of cases Milan Martic, Jovica Stanisic, and Franko Simatovic, and Vojislav Šešelj. At the time, the prosecution wanted all three cases to be joined. And it's quite interesting to look into why they wanted to do this. In its motion of June 1st, 2005, the prosecution on paragraph 23 of its submission alleged that there was a common purpose in this JCE in the three indictments. Chamber 3, presided by Judge Robinson, with Judges Aegis and Liu, denied this motion for joinder, saying on paragraphs 20 and 21 of their decision, and I will quote, the alleged joint criminal enterprise was not identical in all indictments, while noting that there is a partial overlap among the counts, the modes of responsibility, the time frame, and the location of the crimes. In passing, I note that the alleged JCE in the Mrcic, Radic, and Slivančanin case had been mentioned as follows in paragraph 569 of the judgment, which is now public knowledge and which everyone can read. I quote quote, in the indictment letters of the three accused, together with other individuals, including Mirljo Vujovic and Stanko Vujanovic, participated in a joint criminal enterprise, the purpose of which was the persecution of Croats and other non-Serbs who were present in the Vukovar hospital. It is also alleged that the crimes in the indictment were within the object of the joint criminal enterprise, and that each of the accused held the state of mind necessary for the commission of each of these crimes. And at paragraph 608, the trial chamber says as follows. The facts, as the chamber has found them to be established by evidence, do not support the prosecution case that there was a joint criminal enterprise involving any of the three accused, together with others. It adds together with others. This judgment is res judicata. And as far as I'm concerned, it's not subject to judicial notice. But then, if this is the case, if there was no joint criminal enterprise in Vukovar with the members of the SRS, then in this case, in our case, how could there be such a JCE? This being said, I believe that we still have to go further into detail. And before analyzing the conditions that we find in the Tadic judgment, appeals judgment, we must check and examine whether there was a joint purpose between the accused and the other members of the JCE.
En un mot, le projet.
In short, the JCE design, as defined in paragraph 6 of the indictment, which I shall quote again because it is important, aimed at forcing the majority of non-Serbs to permanently leave approximately 1/3 of the territory of the Republic of Croatia, vast areas of the territory of the Republic of Bosnia-Herzegovina, and some areas of Vojvodina in the Republic of Serbia, in order to make these areas part of a new Serb-dominated state. We therefore understand that the ultimate objective is this new state dominated by the Serbs. Is that indeed the design in which all participants were involved, or were there not indeed two designs? The creation of a greater Serbia, claimed by the accused Šešelj, and a second design, which would be the maintaining of a rump Yugoslavia within the former borders of the federal Yugoslavia. And that would be Milosevic's design. This question, of course, calls for greater analysis. Was the way to achieve this ultimate purpose the departure of non-Serbs from Croatia, parts of the Republic of Bosnia-Herzegovina or Vojvodina, or this departure, was it prompted by other reasons which had nothing to do with the creation of a state? It is therefore through the prism of these essential issues that the evidence of the prosecution must be examined. First of all, it is clear that there are two concepts underlying Milosevic's and Šešelj's political action. The obvious conclusion is to say that the design is not identical, and therefore the form of responsibility resulting from the JCE cannot be applied. As regards the second question, relating to the permanent departure of the non-Serbs, it is important to admit that even if the Croats in the Krajina area left the areas in question, we must acknowledge that since the 15th of January 1992, the Republic of Croatia had been internationally recognized within its borders as part of the federal Yugoslavia. Likewise, as regards the Republic of Bosnia and Herzegovina, a new state could not be created from April 1992 onwards, all the more so since the Geneva Conference and the Plan-Owen Plan recognized the existence of predominantly Serb territories in the Republic of Bosnia-Herzegovina, which form the Republika Srpska of today. Lastly, as far as Vojvodina is concerned, it is important to remember that it belongs to Serbia. There was therefore no need to drive out anyone to include this state into the new Serb state, since it already existed and was part of it. If we look into the speeches of the accused against the Croats, essentially, and to a lesser degree against the Muslims, if viewed together, it seems at first hand that the departure of the Croats could be seen as a measure of repression or reprisal following the expulsion of the Serbs from Croatia. And the departure of the Muslims seems to be challenged even by the accused, who believes that these are Bosnian Serbs. This question was addressed at great length by the prosecution, by Mr. Nice, when the accused was testified in the Milosevic trial on the concept of Greater Serbia. The accused, Šešelj, responded to one of Milosevic's question in the following manner. Let me quote. This is an ideological concept which goes way back. This was mentioned in the public arena in 1963, at the time the Turks were defeated before Vienna. This is a concept that goes back to the 19th century. I have read just about all the judgments that were rendered. A great number of witnesses talked about Greater Serbia. They have no idea of what this means. And I must say that this is taken as a fact. In my capacity as living nationalist and ideologist, I can provide you with an original explanation for this concept, and this would be useful for this particular trial and for other trials as well. He probably was thinking of his trial, because as far as all the people mentioned or as part or as members of the JCE, no one, save myself, ever talked about Greater Serbia. And no one ever strived after this. My commitment to Greater Serbia is a commitment that has lasted 30 years and that is now being used to accuse other people, and that has got nothing to do with it. I'm prepared to die for this concept. Transcript page number 43214, and he will add on page 143216, let me quote, the concept of Greater Serbia implies a unified Serbian state that would include all Serbian lands where Serbs are a majority population. However, this runs counter to the endeavors of the Vatican and Austria and other countries who aim at reducing the Serbian people to members of the Orthodox Christian religion, because the Serbian people in its ethnic being include Orthodox, Catholic and Muslim Serbs equally.
Toutefois, cela est différent des
This does differ from persecutions for religious reasons. Sent on page 43122, the accused says that the concept of Greater Serbia cannot be identified with any kind of practice of persecution against the Muslim or Catholic population, because in all the documents that relate to the Serb Chetnik movement and the free Serb movement and the SRS, we Orthodox, Catholics, Muslims, Protestants, and atheist Serbs, we all agree to get along together and to unite. The concept of a Greater Serbia and the concept of ethnic cleansing, there can be no connection established between these two. This is what I wish to say, but you keep on interrupting me, and this is why we stress the following necessity, that our party includes Catholics and members of different religious communities, and we give them high-ranking positions. His action describes Serb rebels fighting against Croats, and seemingly the action undertaken was not a priori based on ethnic cleansing, but merely on the takeover of an autonomous region which seemed to be the objective in mind. I shall look into this now in greater detail. According to the indictment, there had been a ceasefire between the JNA and Croatia. The JNA withdrew, leaving military equipment behind, and that is how the Republic of Serb Krajina was created, RSK. Arkan's group established his base in a former military camp of the JNA in Erdut in Croatia. It is important to read the indictment, therefore, because the indictment says as follows, and this stems from the OTP.
L'acte d'accusation dit
What?
en Bosnie-Herzégovine,
Which speaks with one voice. this deteriorated, the situation deteriorated into an open conflict, and Arkan's tigers were deployed in various communities in which a great majority of the population was non-Serb. Biljana and Zvornik were among these towns. It is important to note that it is a situation that deteriorated and turned into open conflict, and no reference is made to any specific design on the part of one or other belligerent to launch some form of ethnic cleansing. In that same indictment, it is specified for one municipality which is not included in our indictment, i.e. Sanski Most, that between 1992 and September 1995, a large part of the Muslim and Croat population had fled when the population that had remained behind had been subjected to a draconian regime. This reference was provided by the prosecution and related to the fleeing Muslim and Croat population, and does not make it possible, for lack of evidence, to know whether the population had fled out of fear of the fighting or for some other reason. Which enables me to establish a link with the footnote on page 429 of the prosecution's pretrial brief. Footnotes are always important, and it's important to review these. This is what this footnote says. Let me quote. During this period, a unit of the Special Police of Sremska Mitrovica was seconded to Hetkovci to prevent the non-Serbs from being driven out, attacked, or harassed. This sentence, which describes a particular incident, the fact that the police was sent there amply testifies to the fact that at the time there was no collusion between Vojislav Šešelj and members of a JCE, since the authority in power, far from collaborating with a view to achieving the common design, was opposing it by sending the police there. This may tend to prove that the discriminatory campaign of the accused, and I shall have an opportunity to revisit this, was only conducted by him, assisted in that by some of his volunteers, as some witnesses have indicated. Does not mean that the persecution were part of the common design of the JCE aimed at forcing the non-Serbs to leave this municipality. This will be examined in greater detail in the chapter entitled Crimes Physically Committed by the Accused, Persecution, Deportation, and Forcible Transfer. Lastly, to fully understand the JCE, the crucial piece of evidence, in my view, is Exhibit P31, which are the transcripts of the accused Šešelj's testimony in the case the prosecutor versus Slobodan Milosevic. If we look at the 1,692 pages, a careful review of the transcript pages show that there was a contradictory debate on the alleged JCE between the prosecutor, Mr. Nice, the witness under oath, Vojislav Šešelj, the accused Slobodan Milosevic, and the judges. This piece of evidence, Exhibit P31, is all the more important that the statement of some of the witnesses, who were either victims or figures very far removed from power, or expert witnesses employed by the prosecution. According to the prosecution, through the words uttered by Mr. Nice, transcript page 43248, Šešelj and Milosevic purportedly shared the common design to create a Greater Serbia and to drive out the majority of the non-Serb population. The case of the prosecution rests on the following predicate. The Greater Serbian movement created during World War II would be
1240.
What lay behind this movement and which the SRS and Šešelj strived after, as well as the SPS and Milosevic. 44240. The prosecution alleges that these is predicated by the concepts put forward by both parties, and the designs are close in the way they were fulfilled. 43255, 43260, 43262, 43263. The prosecution alleges that the Milosevic regime had provided the accused with privileged access to the media to enable him to disseminate his message of hate and therefore to instrumentalize him in his own interest. Pages 4452, 4453. The idea of Greater Serbia is something which goes back in time, was created after the successive invasions of the Balkan during the Ottoman Empire and were invaded by the Austrians and the Russians. It seemed that the word itself, Greater Serbia, first appeared in a memo addressed to the Russian Emperor in 1803, after which this term was used again by various intellectuals in Serbia and political organization, and was picked up again by Vaza Kubrilovic and Dragan Vasic before being banned by the communist regime. The idea of Greater Serbia seems to contradict the Federation of Yugoslavia, because it first and foremost relies on the idea of a united Serb state. Greater Serbia should be a centralized state and unitary state, which, whilst admitting that ethnic minorities have their rights protected, would nonetheless do away with the autonomous provinces. 43322. The Greater Serbia would encompass all Serbian land, i.e. land where the Serbs are in the majority. According to the accused, the Serbian people is not defined through its religion, but through its language. The language the Serb people speak Stokavian. 43113. I'm using the conditional tense. It seems that 3 dialects are used in the former Yugoslavia: Stokavian, Kekavian, and Kashkavian. As regards this question of the various dialects, there are 10 or so articles that refer to this. I shall not quote them now because this would be too time-consuming. According to the prosecution, all the people that speak Stokavian are Serb, irrespective of their religion. Page 43217. According to the accused interpreter's correction, all the Serbs speak the same language, Serbian, which is stems from Stokavian, page 43219. Therefore, according to the accused, the Croats and the Bosnians would in fact be Catholic and Muslim Serbs, and the creation of Greater Serbia would imply convincing the Croats and the Muslims that they belong to the Serbian people. Page 43220. This interprets correction, very important, replace prosecution with the accused. Serb lands do not quite match up with Yugoslavia. 4321. Stokavian is essentially spoken in Serbia, Bosnia-Herzegovina, Montenegro, and a large part of Croatia. This territory forms the territorial base of Greater Serbia as imagined by Vojislav Šešelj. Therefore, Greater Serbia is what is called Serboslavia, i.e., Yugoslavia, from which Slovenia and the Kashkavian part of Croatia would be taken off. Page 43837. Karlobag, Mitrovica, Ogulin, Karlovac line coincides with the western frontier of Greater Serbia as viewed by the accused. This line forms the limit of Serb lands to the west, where the three provinces of Zagreb, Križevci, Varaždin lie. These form the Kashkavian Croatia, cradle of the Croat ethnicity. This line is not a border as such. This line seems to coincide with a historic and linguistic view of the region. Page 43437. The underlying question in the accused testimony in the Milosevic's case consequently rests on the meaning of the common design in the alleged JCE.
To prove the existence of a common purpose, is it enough for the prosecution to prove that the JCE members shared the will to have a Serb state encompassing all the Serbs? Or is it the opposite, namely, that the common purpose must be specific? For instance, must mean that there are converging views as to the model of statehood they advocate and its underlying ideology. The prosecution acknowledges that the purpose of having all Serbs living in one and the same state is different from the historic and philosophical concept of Greater Serbia. So this is what the prosecution said in the Milosevic case. It added that the accused Milosevic never resorted to the words of Greater Serbia as such, and was never even associated with those terms. Allegedly, Milosevic, because of his position, only or merely made it possible for people championing the concept, such as Šešelj, to speak in favor of it, to work towards it. Transcript pages 43224 to 43226. However, in the prosecution's view, the fact that the accused Milosevic aimed at having all the Serbs living in one and the same state makes it possible to say that the accused objective can de facto be characterized as Greater Serbia. I mean, now we're talking about accused Milosevic. In this respect, Mr. Nice, as prosecutor, but it could equally be Mr. Markuson. It's one and the same thing. So the prosecutor added the practical facts, the specific effect of what the accused sought to achieve are the same as to its geographic scope, to the effect of the implementation of a plan of Greater Serbia of the type advocated by the witness, page 43246, because the decisive factor is the affirmation, the wish expressed to have all Serbs living in one state. That's de facto, and that tallies with the geographical scope of what would be obtained and reached by those advocating the cause of Greater Serbia. Page 43249. The prosecution further argues that once it was no longer possible to maintain Yugoslavia as a federal state, it became necessary to have another plan, which indeed was implemented. And in the prosecution's view, it is then that the idea of a Greater Serbia became a reality in his mind. Page 43259. And this view, this way of seeing things was challenged both by Milosevic and Šešelj. In their approach, the prosecution, as represented by Mr. Nice, identified the fact that all the Serbs lived in one and the same state, Yugoslavia. It is then made identical to Greater Serbia. This is stating a fact that exists ever since Yugoslavia has existed. This is a fact that comes from reality. It is, I quote, a concrete, tangible, material fact. Page 43240. As Slobodan Milosevic would have it, such a concept of the common purpose is in contradiction with the fact that Yugoslavia encompassed the entire Serb population within one and the same state, and that the said state enjoyed full legal capacity in the international arena. He observes in this respect that, quote unquote, all the Serbs in one and the same state is not a slogan. It has been a reality for over 70 years, from the very inception of Yugoslavia until 1991. If Mr. Nice accused somebody of wanting to save and maintain a state that has been an internationally recognized sovereign state, one of the UN founding states after World War II, I suppose there would be an endless list of individuals to be indicted by this tribunal. Page 43264. In support of this, it is worth pointing out that Šešelj, as a witness, then added this: the SRS has drawn up a geographical map of Greater Serbia. This map has been published by us, I don't know how many times, numberless times, on the front and back covers of our journal, Greater Serbia. And it can be seen that the western border is on the Karlobag-Ogulin-Virovitica line. This map of Greater Serbia encompasses not only the territories where there is a majority of the population that is Serb Orthodox, page 43274. He added this: nobody ever said anything linked with territorial claims by Serbia. The Serbs within the Croatian federal unit at the time made it clear to the Croats, if you want to secede from Yugoslavia, we don't want to. We want to stay within Yugoslavia. It was very clear before every war began. We did not want to leave Yugoslavia. You did. Transcript, page 43275. What the Orthodox Serbs wanted was to rescue Yugoslavia, and they did not want a greater Serbia. Most of the Serbs did not want a greater Serbia. Only the SRS wanted it. End of quote. Therefore, based on this, the former Yugoslavia, as Milosevic would see it, was a state encompassing all the Serbs. And when it dissolved, when it exploded, it raised the issue of how to reconstruct, politically speaking, the Serbian people. Therefore, with regard to the prosecution position in the Milosevic case, on account of the positions by the accused Milosevic and Šešelj, the question whether there is or not a common purpose or a common criminal purpose could be put in the following terms. Is the criminal purpose to be defined by its final objective, the gathering of all Serbs within a common state, or is it to be defined by a plan to implement a specific model of statehood based on a specific type of political ideology? In the former case, it may be said that there were discrepancies, ideological discrepancies between Šešelj and Milosevic, but that at first sight there may have been a common purpose, uniting them with others. And the ensuing result would have been the creation of a Serbian state or keeping a model of statehood encompassing all the Serbs. However, such a concept runs up against major obstacles. I have to end because this is absolutely capital and I only have a few minutes left. However, such a concept runs up against major obstacles, namely that it doesn't take into account the fact that Yugoslavia pre-existed, and therefore it is in contradiction with the fact that all the Serbs were de facto included in the Yugoslav state, the existence of which Milosevic was endeavoring to keep. And another consequence of this concept would be that you would put in the same JCE individuals who only had rather sporadic, intermittent contacts, because they had maybe pursued a final objective with arising conflicts of interest among them. In the latter case, it appears that the objectives pursued by Šešelj and Milosevic are different. Milosevic wanted to keep a form of statehood that existed before, the federal state, which would have made it possible for Serbs to remain within one and the same state. However, Šešelj wanted a unitary and centralized state, putting together historically Serb lands in which the inhabitants would speak all the same language, Stokavian. Based on all these parameters, a reasonable trier of fact could not conclude beyond any reasonable doubt that the accused Šešelj shared the same objective as the other JCE members, because their final purpose was totally different. I can therefore not find that the accused participated in a joint criminal enterprise aimed at forcing by crimes against non-Serbs, those non-Serbs to leave a third of Croatia, large parts of the Republic of BiH, and some parts of Vojvodina in order to integrate these areas into a new Serb-dominated state. After the break, I shall move on to the issue of persecution. We shall break for 20 minutes.
All right, we will leave.